this whole risk thing has been everywhere. I'm seeing Andrew Tate's lawyer talk about risk. You know, as we know, Boone was in jail for 15 months on risk, and I could care less about anything Andrew Tate related, but when he starts talking about court, I started listening. And he said that the first time they held him 4 months as an alleged risk, they introduced this lady, her statement to the court. I've never tested it, never questioned it, and they seized all of his assets, house, cars, phone, money, gold, and it's all because of this alleged risk that I believe is fully untested. And so there's a bridge that is built, and you know, no source, no rules, no facts. It just goes straight into a finding, and then detention. And so now they're holding these people, Boone, Andrew Tate, famous people, regular people. It's all risk. I'm noticing it's risk, risk, risk. So now he just got arrested again, and his lawyer goes on TV and goes, "Oh, they've labeled him a flight risk." So I'm just wondering, what facts prove that he's a flight risk? What risk? What behaviors back up the fact that he's an actual risk? Is this being questioned, or is risk just this thing, this pre-trial punishment, pre-proof punishment that they're using to just fillet everybody?
I would agree. They're definitely filleting everybody. In Canada, here, it's no different. That's their go-to move. If they can't, nail you down with an actual criminal charge, then they fall back.
Sorry, brother. Sorry. Go
No,
ahead.
then they fall back. They start with that. They start with the sirens. They come in hot, and after that, you're left usually with a piece of paper, thinking there's a criminal charge, and then it ends up like this whole Tate situation where they do administrative paperwork and sleight of hand with the lawyer to ensure that the same outcome occurs, or if not worse.
It's amazing. It's honestly quite amazing, bro. And so now, how long are they going to hold him on this alleged flight risk? Have they proven he's a flight risk? Is there any proof that Boone was an actual risk? Was there any proof that Tate was a risk the first time? Was there any proof that Tate is a flight risk this time? And is the proof of the risk even being questioned? I'm thinking that it's weak facts, weak risk, just like you see on the screen here, and it's just being allowed to stand. That's what I really feel like is going on, bro. That they know how to allege something that you don't know how to question. And then it stands as risk, and then you go along for the ride.
Yeah, what seems to be the wording that they choose when speaking with them is an allegation occurs, and that's what we're up against is an allegation. So an allegation that ends up as an information, right? So this allegation, which is a complainant, complains of some sort of maybe even horrendous acts, and the police come in hot and heavy, and the police generally, they talk to their lawyers about these charges, sometimes even before anything goes to court. So there's a police DA slash Crown interaction that determines how the court's going to see it.
If we've gone over the roles of the prosecutor, and the prosecutor's role is to manage the cases, where in there is his goal or role trying to win for you? You see what I'm saying? And what I'm saying, why I'm bringing this back is, if his goal is only to manage cases, then why in the world would he ever be questioning risk? He's only going to play hardball or so-called seeming hardball when he's supposed to, which I think is later in the trial when they're arguing about other facts. But But when it comes to the facts that go into the risk assessment and the risk label, I think it's almost like hush hush. You don't even talk about this. That's why I think we're not seeing lawyers push back on this when we're studying these court, videos. I think I think this is one of those no spots. Like you don't push on this because this would show us too much. I think that's just a thought. That's an opinion. You know what I mean? Like normally I never share those, but that's just kind of like what I'm suspecting.
Yeah, like when you brought up the Tate thing, when you were bringing up how, what did the lawyers even bring up? What was actually, brought to the table to help Tate out in this situation of an allegation and it becoming some sort of information that is brought to the court. This what would appear like a no-no or you'd hold up a human-like figure and then you'd say, well, where are the no-no spots? We're
I
under
used to
the
say that
impression.
on the back chat all the time. Sorry. Go ahead.
So when we're looking at this, looks like it's a no-no. It's off the table for these lawyers. I would say that the comprehension level of the lawyer is unable to actually comprehend this aspect of their job.
In the training of procedure, it's just not even a part of it. Maybe they're trained to fight in other places intentionally.
Well, I think that would happen naturally. If one aspect is confusing, then you're probably going to lean on what you're more comfortable with, right?
Well, they all actually say that they specialize in one area mainly. And even if they specialize in two, three, four, five, it's still just those five out of thousands of areas or hundreds of areas, however many. You know what I mean? So, what are the odds if they specialize in, you know, hospital malpractice? What's the odds that they even know about risk? You know what I'm saying? They're trying to prove malpractice. Are they even focused on risk? If you're a trial lawyer, you're trying to disprove the case. You're trying to prove not guilty. You're not even, you know what I mean? Like everybody just so far past risk. And it's like, I don't know. I just feel like if we focused on this at the beginning, then the whole thing starts off with less evidence that you're even a risk. I think if the whole thing starts and goes off of this thing of this guy's a risk, this girl's a risk, I think you're already, you know what I mean? You're already fried, bro. I think you're already fried. I mean, if it goes your way, I think you're just lucky, dude. But like when I see, what I'm saying is, instead of tearing apart the risk allegation, normally you see like a defense start to go to bonds. Can we lower the bond? Can we agree to this? You know what I mean? Can we do time served stuff? But I never see them actually trying to tear apart the risk allegation. That's kind of what I'm saying.
Yeah, that's because the risk is not something that exists. There's nothing for them to handle. The risk is for the acceptance or confusion that it's still an allegation, which comes with an information, which is still a charge. So it's not pre-crime. It is an allegation, which is of something, and they're going to prosecute you under the presentation of a pre-crime risk-based situation when it's not. It's actually a conviction, and they're just going to keep it off the record, so to speak, as to keep the bond off the record, because they will say to you, it's just the name of a file. There is no real bond.
Oh, he said the same thing you said also. He said that the file was just sitting on the prosecutor's desk and there was nothing actually filed. He said it sat there for a year. And I was like, bro, that's why I said it to you. I'm uninterested in him as a personality as well. But bro, he was saying like four different things that you literally said to me about the case that you've gone through. Four of the same, three or four of the exact same things. Like I mean, word for word. I was like, holy crap! They're using it. They're using the same thing on you as they used on Boone as they used on this guy. I'm just saying, like, I'm seeing the similarities. So now I'm questioning, what is a lawyer challenging? What does the government actually have to prove? You know what I mean? Like, there's findings that the court has to make, and we're just not even asking about them, bro. Preserving nothing. I mean, it's just, to me, is managing. So if we know the lawyers are managing cases, is that the same thing as actually defending somebody? You know what I'm saying? So you're paying somebody or not paying somebody free because you think they're defending you, but they're managing a case. Is that even the same thing? You see what I'm saying? How can we even expect to be defended if their job is case management?
Well, I mean, whenever I've been in front of a lawyer, I can't recall ever asking, "Are you going to defend me or help me or whose side?" I never asked any of these questions. Maybe they'll tell you, "No, we're going to make sure you're prosecuted." Managing that you're prosecuted.
That's right. I'm managing. I'm gonna get you less than they're offering, and you're gonna think it's a deal. Managed.
There you go.
I managed you. I managed them. I manage it all together. I manage it. They want all this. You want none. I'm gonna manage both of these concerns for you. That's not winning though.
They're managing you.
Yeah. Yeah. I agree.
Yeah. So that's what we're pointing at now, which is the obviousness, is that the whole chain of events are just done through acceptance. We're accepting what they're saying because at any point we need to ask, where did one read what they're saying? Because if they're saying something and it's supposed to be authoritative or based off some sort of law, then it needs to be written somewhere. So, good question is, what can you show me what you read that makes you say that?
So it sounds like you're asking about what they're referencing when they consulted to quote unquote what they're referencing as far as the authority goes. And so to me, everything that matters has to be a question of authority as far as if the judge it can do anything about it, can say anything about it, can address it. He's not even going to address it unless it's a challenge to some authority. So to me, it sounds like what you're saying is the basis of a challenge to the authority of what they're even going off of. So I mean, I like it. I'm unsure how the court would respond to that wording. I've yet to think about it in detail enough to see if that procedurally is what they would like to. You know what I mean? Because like there's a way, there's things we like want to say, and then there's a way to say it procedurally where they can hear it. That might be the perfect way. I'm just unsure. But I think what we're getting at is something very important. What you're getting at. I'm just listening.
Yeah. Well, I mean, what it comes down to is that anybody that opens their mouth that is essentially saying that they're demanding something. When anybody is demanding something or presenting like it's a demand, and one doesn't ask them, how they've come to this, that they've decided to say this to you. You wonder, did they come up with that on their own, or did they read it and that's the reason that they're saying it to you? So if they didn't read it and they're saying something to you that they didn't read, then it has no authority.